The U.S. bankruptcy judge overseeing FTX's Chapter 11 proceedings is considering a request by the U.S. Justice Department to appoint an independent examiner to investigate the exchange's collapse, and that decision may come today at a court hearing in Delaware. Joining us now to discuss with more legal analysis is Murphy and McGonigle founder James Murphy. Thank you for joining us this morning, James. So FTX is opposing this independent investigation, saying it would be redundant and wasteful. So why does the Justice Department feel it's necessary?
Well, Christine, the idea here is that you really need an independent, completely independent party to conduct an examination in a circumstance like this, where what we're talking about is one of the largest frauds in U.S. history. And so because the current debtors counsel, Sullivan and Cromwell, had done a substantial amount of work for these debtor entities, they really don't qualify as independent. And the value of a report from an independent examiner is significant. It can lead to recoveries against third parties who may have enabled the fraud. They may not have been knowing co-conspirators, but they could have enabled the fraud by not blowing the whistle when they should have, and that could be auditors, accountants, bankers, and lawyers. And I think finally, people saw the benefit of a independent examiner report very, very recently, because the Celsius independent examiner report just came out and really broke new ground that people did not know, that essentially the examiner concluded that Celsius had all of the indicia of a Ponzi scheme, and he pulled out some really telling emails where people were referring to themselves as enablers of a Ponzi scheme. And they say they were joking, but when you are actually working at a Ponzi scheme, it probably is not a good joke.
The John J. Ray has said that one of the arguments he makes against having this examiner is the amount of cost that he's familiar with, given what happened with Enron, with the unwinding of Enron, and it was something like over $100 million, I believe, was the number for the independent costs here. Yeah, is that kind of what we could expect here in FTX, that this kind of cost, or does Ray have a point?
Well, it's going to be expensive. There's no question that it will be expensive. But, what we're trying to analyze is, what is the value of a report prepared by Sullivan and Cromwell that was there at the time and may have some responsibility conceivably for enabling the fraud. This is the position that's been taken by the 4 bipartisan senators who sent in a letter to the judge strongly urging the appointment of an independent examiner. This is the position of 18 U.S. states who've all entered into the case and said, we really need to know this story, and the source is important. It needs to be a truly independent source. And those 18 states is kind of interesting. You have the states of Hawaii and California, on one end of the political spectrum, and you've got the states of Texas and Florida all agreeing that we really need transparency here. There needs to be a record of what happened here, because a lot of people were injured, victims. There are millions of FTX victims spread all over the United States. And, Congress has said we may need to legislate in this area. And so having a report from an examiner in a circumstance where you've got really a fraudulent catastrophe hurting a lot of people makes a lot of sense, and it'll be expensive. But if you look at Enron, that Enron report led to claims and recoveries against lawyers and bankers for Enron in hundreds of millions of dollars that were distributed ultimately to creditors. So there could be...
Is that a concern for Sullivan and Cromwell? Because they formerly advised FTX before they went insolvent. And they have been questioned by Sam Bankman-Fried, a couple of senators, about their conflicts of interest in representing them in this case. And so in choosing an independent examiner, how is that process done in a way that it ensures independence?
Well, there are very strict rules. For instance, the law firm or the lawyer that's picked to lead the investigation can never have done work for the debtor entities, which of course makes sense. And that's the problem for Sullivan and Cromwell. So there will be no question that whoever is selected, if the judge grants the motion, will be independent. And, you know, in the Voyager bankruptcy, just within the last couple of days, an email came out from a Sullivan and Cromwell partner where he was representing in an email to a third party that FTX was rock solid. That was the quote. And he said that 4 days before the bankruptcy. And so now these lawyers at Sullivan and Cromwell are going to find themselves witnesses in the Voyager bankruptcy, and they could very well be witnesses in the case against Sam Bankman-Fried. And so there's a pretty well understood tenet in the practice of law that you can't be both an advocate and a witness in the case.
Interesting. Also, we have the hearing today. What are you watching for in today's hearing with FTX?
Well, it'll be interesting. I think everybody in the courtroom, all involved, have a lot of respect for John Ray. So this is going to be a mini trial. It's not just going to be lawyers arguing to the judge. The intent here is that they're going to call John Ray to the stand, and he'll be sworn in, and he'll be asked questions by Sullivan and Cromwell. And then the U.S. trustee will have an opportunity to cross-examine Mr. Ray, and my guess is they will seek to make it very, very clear that Sullivan and Cromwell has conflicts as a consequence of its representation, not just of FTX entities, but of Sam Bankman-Fried himself and another senior executive at the company. By Sullivan and Cromwell to be independent. And those individual representations are pretty important. In your earlier segment, you talked about the ownership of the Robinhood shares. Well, Sullivan and Cromwell advised Mr. Bankman-Fried personally with respect to issues around ownership of those Robinhood shares. And so now the ownership is disputed, and Sullivan and Cromwell was there in the middle of it. And that's just one example of the difficulties they're going to have in portraying themselves as independent.